Hello everyone, my name is Elena Valentine and I will be going over Chapter 10, Strategies to Reduce Liability. Going to the first slide, using tools to reduce liability. Being aware of the possible tortious events that can occur while delivering healthcare is not at all the same as knowing when a negligent act will take place. Risk management must be able to accept that people will suffer injury from negligence, and as a result, they need to establish conditions in order to minimize the risk of a tortious act. Next slide. Professional Practice Acts. Statutory definitions delineate the scope of practice and the degree of interdependence with other practitioners and uniformly grants physicians the power to diagnose and treat patients. Regulatory boards for each profession are created by statute. Legislation specifies the composition of board, its duties, and broad powers to create rules and regulations for specific requirements for professional practice. Licensure process is detailed, can include state guidelines for mandatory continuing education and continuous monitoring of health professionals on behalf of the public. Professional discipline involves investigation and prosecution of allegations of profound misconduct of licensees as well as the illegal practice of the profession by unlicensed persons. Categories of misconduct include repeated acts of negligence, incompetence, aiding or abetting the unlicensed practice of medicine, failure to comply with government rules and regulations regarding the practice of medicine, exploitation of patient for financial gain, evidence of moral unfitness to practice medicine, failure to maintain appropriate patient medical records, abandoning or neglecting a patient, harassing, abusing, or intimidating a patient, ordering excessive tests or treatments, and unlawful use of controlled substance. If investigation reveals evidence of substantive misconduct, the involved professional will be notified of the nature of the claimed misconduct and a formal charge. Adverse actions can include revocation, suspension, or limitation of license, probation, censure, and reprimand. Next slide. Impaired professionals. When medical impairments adversely affect professional judgment, patient care, collegial expectations, and social role, interventions become necessary. A Yale University medical professor found through interviews that healthcare professionals have a remarkable ability for denial, continuing to practice despite pain, and reluctance to disclose their diagnosis for fear of losing professional standing. Additional risks to professional competence can be incurred through alcohol abuse, chemical dependency, and psychiatric diagnosis. Symptoms need to be recognized and appropriate actions taken to prevent untoward professional activities. These symptoms include making late rounds, inappropriate orders, complaints from staff, frequent accidents, hostile behavior, and many more. The PCA, which is the Physician Assistance Committee, accepts referrals from a variety of sources, arranges for specific evaluations, refers physicians to treatment, monitors compliance, and advocates for physicians as long as there is compliance with treatment agreements. The Committee for Physicians' Health is a division of the Medical Society of the State of New York and monitors approximately 550 physicians recovering from substance abuse and psychiatric disorders. The activities of CPH are confidential and protected by state and federal law and are immune to legal charges. CPH does not report physicians to the OPMC as long as they participate, stay with the program, and are helped by treatment and do not present imminent danger to the public. Next slide. Sexual misconduct. In the healthcare setting, sexual misconduct typically is the result of the difference in power residing in the dependency of the patient on the professional who exploits those opportunities. There is a long-standing consensus with the medical profession that sexual contact or sexual relations between physicians and patients are unethical. Sexual contact that occurs concurrent with the patient-physician relationship constitutes sexual misconduct. In other words, any sexual contact between the patient and the physician during a professional medical relationship is considered sexual misconduct. Physicians who partake in sexual misconduct are dealt with punitively by state licensing agencies and boards of professional medical conduct. Physicians charged with sexual misconduct are seen as an embarrassment to the professional community, as they should be. Psychiatrically impaired physicians, unfortunately, have a poor rehabilitation outlook. Next slide. Federation of State Medical Boards. The FSMB and the Federal National Practitioner Bank help licensing boards share information across state lines concerning adverse actions taken against professionals. The annual summary of board actions is a compilation of disciplinary actions initiated by its boards. The FPDC contains disciplinary actions related to physicians dating back to the 1960s and is available for licensing and disciplinary boards, government and private agencies involved in employment credentialing of physicians. The Federation Credentials Verification Services was established in 1996 and maintains a database of physicians' core medical credentials on medical education, postgraduate training, licensing examination history, and board action history, and serves as a lifetime professional portfolio. The Federation Physician Data Center and Federation Credentials Verification Services serve to enhance medical licensing and disciplinary systems. Next slide. National Practitioner Data Bank. Due to an overwhelming amount of medical malpractice suits, the perceived need to improve quality of care, and the necessity of professional peer review, the Healthcare Quality Improvement Act was signed into law on November 14, 1986. Later, that law underwent provision to form the National Practitioner Data Bank. The NPDB was designed to collect comprehensive data on adverse actions taken against healthcare practitioners, malpractice payments made on their behalf, and Medicare or Medicaid exclusions of practitioners. There are 4 classes of adverse actions which require reporting. Those that are taken against a practitioner's license by a state medical or dental board, those taken against a practitioner's clinical privileges as a result of peer review at a hospital or other healthcare facility, those taken against membership by a professional society, and those taken by Medicare or Medicaid and the Drug Enforcement Agency. Insurance companies and hospitals are required to report to the Secretary of Health and Human Services and state licensing boards regarding medical malpractice payments resulting from court judgments and settlements. Failure to do so results in a $10,000 penalty per claim. Hospitals are mandated to query the National Practitioner Database about all new medical staff professionals, along with doing so every 2 years for all staff for recredentialing purposes. Physicians and other healthcare practitioners are sent copies of all reports received by the National Practitioner Database that name them. They may submit a statement for the record and have the right to dispute the factual accuracy of the report with or without an accompanying statement. Next slide. Clinical Practice Guidelines. Defined as systemically developed statements to assist practitioners in patient decisions about appropriate health care for specific clinical circumstances. Next slide. Guidelines developed by professional groups. Each of the medical specialty societies may develop its own standards for areas that are relevant to that specialty. Practice guidelines developed by these organizations are issued by experts including the AMA, medical specialty societies, and the federal government. The National Guideline Clearinghouse, established in 1999, is a public resource and comprehensive database of evidence-based clinical practice guidelines and is sponsored by the Agency for Healthcare Research and Quality, American Medical Association, and the American Association of Health Plans. The NCG's mission is to provide healthcare professionals with an accessible mechanism for obtaining objective, detailed information on clinical practice guidelines and to further such guidelines' dissemination, implementation, and use. The National Comprehensive Cancer Network is an alliance of 17 leading cancer centers created to develop and institute clinical practice standards and research on performance outcomes. The American Hospital Association Medication Safety Initiative provides information on successful practices, tools, and resources, and tracks the progress of implementation as a strategy to enhance performance and reduce errors. Unfortunately, due to liability concerns, hospitals are reluctant to use this tool for fear that by using it, they could be held liable for not implementing all of the safe practices recommended. Medical Automated Record System was developed by Kaiser Permanente of Ohio to address the business and clinical needs of its system, which includes 220 physicians and 110 allied health personnel. MARS is programmed to generate reminders at the moment of care on compliance with clinical guidelines and tracks improvements such as the use of aspirin in coronary disease. Next slide. Private initiatives. Medical Review System of Value Health Sciences of Santa Monica, California uses practice guidelines to pre-certify hospital admissions for 34 major medical and surgical procedures, which has resulted in a reduction in the number of procedures requested after implementation, along with saving in excess of $200 million since 1990. Milliman USA is a group of actuaries and health consultants that estimate the U.S. could save 25% of its total healthcare costs if efficient medical practices were adopted. Purposes of these clinical tools is to assist healthcare professionals in providing quality care while maximizing efficiency and the use of healthcare resources. Leapfrog groups want hospitals to make a commitment to quality. Next slide. Government initiatives. Each guideline developed by the Agency for Healthcare Policy and Research, or AHCPR, covers a specific disease and discusses the most effective methods of preventing, diagnosing, and treating that condition. AHCPR guidelines development aims to help physicians make better decisions and reduce ineffective and inappropriate services. Arkansas Patient Safety Initiative is a forum for discussion of issues, policies, data-driven studies, and dissemination of best practices to achieve quality care. Almost all states have tried to reform their malpractice litigation and defense systems to bring perspective and management to the healthcare industry. Next slide. Guidelines for workers' compensation. In order to better control workers' compensation payments, several states have adopted existing clinical practice guidelines or developed their own. For example, Massachusetts Reform of 1991 granted the Department of Industrial Accidents authority to write guidelines that set limits on the number of reimbursable visits as well as on payments for costly tests. West Virginia's physical medicine guidelines were written as regulations and are more rigorous in halting visits and controlling payments. Next slide. Mandates of insurance companies. Companies involved include Medical Insurance Company, COPIC Insurance Company, MAG Mutual Insurance Company, Medical Professional Insurance Company, Medical Mutual Insurance Company, Medical Assurance Company, and Northwest Physicians Mutual Insurance Company. Surprisingly, physician acceptance has been nearly universal. Next slide. Legal implications of practice guidelines. Tort liability could increase if it is alleged that defective practice parameters result in harmful patient outcomes. Antitrust violations could occur if the standards are developed to protect the economic interests of specific groups of physicians. The Mutual Insurance Company of Arizona has required its insured anesthesiologists to sign a preferred risk plan and agree to comply with underwriting requirements on patient monitoring. Next slide. Physician attitudes towards guidelines. Despite the fact that physicians have evidence-based guidelines at their disposal for dozens of conditions, they are having problems across the board implementing them in their own practice. Some physicians see guidelines as being too impractical or oversimplified, a threat to their autonomy, or not completely justified by the scientific evidence. Next slide. Peer review. The goal of peer review is a comprehensive and equitable evaluation of medical practice to enhance the quality of care and to reduce mortality and morbidity. Confidentiality is a very sensitive issue in regards to peer review. Participants should be cautioned and educated about the vital nature of the peer review process. There are 6 major reasons for peer review: identified quality concerns, hospital privileging decisions, group practice membership decisions, staff conduct, professional isolation, and education. There are three major components of peer review. The first major component is peer evaluation of clinical judgment, using written documentation, established clinical guidelines, and patient care protocols. The second evaluates technical skills, not only in terms of appropriateness, but also in performance outcomes. The third peer review uses practice profiles to assess resource utilization and efficiency of the care process. Risk management strategies argue for fairness in the evaluative and support processes and attention to peer selection. The importance of outcomes as a measure of performance and quality of healthcare gives an impetus to the development of standardized criteria to be used as a baseline for clinical practice. Such guidelines effectively reduce extremes and shift the focus toward quality care. The Joint Commission has expanded its interest in sentinel events and have introduced national patient safety goals to address some of the occurrences. The goals are improve accuracy of patient identification, improve effectiveness of communication among caregivers, improve safety of using high alert medications, eliminate wrong site, wrong procedure, wrong patient surgery, improve safety of using infusion pumps, and improve effectiveness of clinical alarm systems. Next slide. Liability alternatives. Due to skyrocketing malpractice insurance rates, physicians are being forced to curtail their practices or move to states with lower liability insurance rates to avoid debt or bankruptcy. This has brought talk of tort reform to change certain legal rules or limiting the damages that can be awarded. These conventional tort reforms are being labeled pro-defendant because they limit the amounts that plaintiffs can recover and block the courthouse door. There are three types of traditional tort reforms: limiting the number of lawsuits, which includes setting attorney fee limits, certificates of merit, pretrial screening panels, penalties for frivolous litigation, and statutes of limitations. Controlling the size of awards involves putting a cap on monetary damages, establishing a schedule of damages, reducing awards by the amount collected from other insurance coverage, restricting joint and several liability suits, and scheduling periodic payments of damages. And the final one is limiting the access of plaintiffs to the system deals with expert witness requirements, informed consent limits, and res ipsa loquitur restrictions. All of these proposals address the plaintiff's difficulty or costs of winning a lawsuit. Next slide. Removing malpractice litigation from judicial systems. Administrative agencies could adapt trial-like procedures, but would have much more leeway to avoid time-consuming pleadings. When needed, expert panels could examine sophisticated medical evidence. Tax money would establish the administrative agencies and compensate arbitrators. Both mediation and arbitration remove procedure-bound litigation from the courtroom and placed it in an informal setting to resolve the problem. Mediators negotiate agreements, while arbitrators can make judgments and impose awards. No-fault proposal system. Any adverse outcome would automatically be compensated without lawsuits, regardless of whether or not the outcome resulted from negligence. An untested no-fault proposal uses adverse medical outcomes called avoidable classes of events as a mechanism for deterring liability for selected injuries. ACEs are also known as accelerated compensation events. Under the ACE system, medical experts identify categories of injuries that are generally avoidable when a patient receives good medical care. Those patients would automatically be compensated through an administrative system and be paid by the physician's insurer or other responsible organization. In the enterprise liability system, physicians would be immune to lawsuits rather the institution in which they practiced or the health plan responsible for paying the medical services provided would assume the liability. This would help to eliminate the costs associated with multiple defendant suits, facilitating settlement. Early offers is an innovative approach to liability that attempts to provide a new set of balanced incentives to encourage doctors to make offers quickly after an injury to compensate the patient for economic loss and for the patient to accept such offers. Next slide. To tort or not to tort. A Consumer Report article suggested that many of the proposed changes would tip the scales of justice against consumers. Physicians argue that the medical liability system is flawed because there is no timely and adequate compensation for injured persons, negligence is not deterred, fear and distrust are promoted, healthcare providers are not given incentives to prevent and detect injuries, the physician-patient relationship is harmed, and physicians change their behavior because they are vulnerable. Proactive liability reduction. Professional Practice Acts, next slide. Professional Practice Act's Clinical Practice Guideline and peer review seeks to prevent adverse events from ever occurring in the first place. Tort reform and non-judicial alternatives aim to resolve conflicts rapidly, equitably, and inexpensively after an injury occurs. Regardless of the basis for the protective liability reduction activities, this area can offer significant protection of the organization's financial resources. And that is the end of this very long presentation. My question to you all is, do you think that there should be a federal tort reform? If so, what implementations would you make to keep the fairness balance between patients and physicians? Defend your answer. Thank you guys for being patient and listening to my presentation.